When I talk with my colleagues at the OSC right now about the cannabis industry, they all express a bit of angst. Basically, you're in a situation where investors perceive a gold rush, and when you're dealing with that type of a situation, you tend to see fraud or people being misled. So, cannabis is even more complicated than what you would typically see in an emerging industry. In addition to uncertainties that are inherent to a new industry, there's significant regulatory uncertainty as well. And this is a result of the fact that our neighbor to the south has taken a different approach to cannabis. Add all of this up, and you have regulators that are alert and cautious. This in turn creates a regulatory situation that can be complex for market participants, that is, people who are actually out there trying to raise capital so that they can, produce or sell cannabis, as well as for investors. So I'm going to try to break all this down for you tonight and give you all a little bit of information. We're going to go over some of the risks, discuss the regulator's response, which is primarily seen in the disclosure that they're requiring market participants to put out. And then finally, I'm going to discuss how the reactions to the risk have affected the different ways companies can access capital markets. And in the end, there's two goals. I hope that the investors in the room are going to be aware of some of the risks that they should expect when you're in this market, and also the companies that are directly and indirectly, and that's an important distinction I'm going to talk to later on, involved in the industry should be aware of some of the issues that are going to come up. So as I said at the outset, with any emerging industry, there's going to be some uncertainty. There's always going to be uncertainty at the beginning about regulation, taxation, pricing, and we've already heard about some of that from Lindsay, Gerald, and Ben. There's also business risk. There tends to be a lot of speculation with new companies, and with that you see inflated prices. And we've already seen some of that with the companies that have had IPOs in the States. I'm thinking about Tilray, where you saw a rapid increase in share price that was followed by a bit of a drop. In addition, you could over time see dilution in your shareholding, where as companies try to scale up, they may choose to raise additional funds by issuing additional shares. Now, in addition to the risks that you're always going to see in emerging markets, cannabis has some particular risks that are the result of the different approach to legalization seen in the States. Now, this requires a bit of background to explain. In the States, there's obviously a federal approach and then a state-by-state approach to cannabis. Now, under federal law, cannabis is a Schedule I substance. It's banned. It's prohibited. But the states take a different approach, and from state to state, you'll see that some states are more permissive and others are more prohibitive. Medical use, for example, is actually allowed in 31 states. Recreational use is allowed in 9 states. But this creates a bit of a tension because you have a federal law that says, hey, this is a prohibited substance. State law that says, well, it depends on where you are. So there's a bit of a compromise, and the compromise was struck in 2013 under the Obama administration, under something that was called the Cole Memorandum. Essentially, the DOJ said, okay, look, we're going to take a hands-off approach. We recognize the economic reality here. We're not going to be going gangbuster enforcing our laws. We're basically going to take a back seat to the states. And that was the state of play from 2013 until fairly recently, when, as with other aspects of different industries, as well as just life in general, the Trump administration entered a bit of chaos and uncertainty into our lives. In January 2013, and really without any notice, the Trump administration rescinded the Cole Memorandum. They didn't really put anything in place. They just said, well, we're just going to pull this memo out. It's no longer effective. So that created a bit of uncertainty. It wasn't clear whether federal agents were going to now be enforcing law. They really just left it up to the state attorneys at every state to decide how they were going to deal with the situation. This obviously changes the risk landscape for a company that has a US facing business. You can't really be sure if you, for example, are growing cannabis in Colorado or you're trying to sell in California, whether or not a federal agent might show up at your door one day and have some questions for you. Now, why the US? Why is this such an issue? Well, it's just, as with all things, the size. The Canadian cannabis market is estimated to be about $7 billion, and that's roughly the size of our alcohol market right now, whereas the US cannabis market is estimated to be as much as $50 billion. So you can see why, if I'm a Canadian producer, I might want to try to get a toehold in the American market. So how did Canadian regulators respond to the rescission of the coal market? Well, our gatekeepers got together and looked at what this meant. And in February 2018, the Canadian Securities Administrators, and that's basically just the umbrella organization of all of Canada's provincial securities regulators, basically put out their own memo. And it's a direction to issuers with US-related cannabis activity. It reaffirmed that cannabis companies with US operations could continue to raise funds in Canada. However, they created disclosure requirements that they needed to satisfy if they wanted to continue to do so. And this is where we start to get into a bit of tricky territory for companies. So, what are these disclosure requirements? First, they require a clear description of the nature of the issuer's involvement in the US cannabis industry. Exactly what are you doing? Are you selling in the States? Are you growing in the States? They require a prominent statement that marijuana is illegal under US federal law and that enforcement of relevant laws could be a significant risk to your investment. Then they also require discussion of different related risks, such as the fact that a third-party service provider could suspend or withdraw its services to the issuer, or that regulatory bodies could impose restrictions on the issuer's ability to operate in the US. There's a couple other requirements. One relates to a discussion of the issuer's ability to access public and private capital, and this is actually fairly significant. In the US, major banks will not provide financing for cannabis-related companies, and until recently, that was also the case in Canada as well. Finally, they require disclosure of exactly what percentage of your business is exposed to the US market. Now, there are additional disclosure requirements based on whether the issuer has direct, indirect, or ancillary involvement in what the notice calls marijuana-related activities. And I'm going to get to exactly what those mean now, but you'll see that that's another source of uncertainty. So, what's been the result of these new regulations? Well, they've proven difficult to follow so far. A couple weeks ago, the CSA released a new notice. This one basically just gave an update on where issuers are and how they're dealing with the heightened disclosure requirements. And in short, they're not doing well. 74% of the issuers with cannabis operations in the US, so that's the bottom line there on the chart, 74% did not provide sufficient disclosure related to the US operations. Now, to be fair, I'm focusing on the US-facing businesses, but I mean, there's also enhanced disclosure requirements for Canadian-based issuers. That is, issuers who grow and sell cannabis in Canada. I'm going to talk about those requirements very briefly, but the point is, even those issuers are having a hard time dealing with the regs. And you'll see at the top chart, literally all of them had disclosure deficiencies, and all of them were required to make changes to their disclosure. Now, issuers in this area need to be alive to the risks that this creates. We haven't seen any enforcement action yet from the OSC, but we should expect that when they start, they're most likely going to relate to disclosure failings. Moreover, from the perspective of an investor, you need to be alive to the possibility that you might not be getting all of the information that the regulator thinks you should. And there is additional uncertainty with respect to Canadian issuers who have US-facing business. And this goes to the point that I touched on earlier. It's not entirely clear who exactly these regulations are going to apply to. You should not think that if you're an LP or if you're not an LP that the regulations aren't going to apply to you, because that's not the case. Certainly, if you're directly involved, and that is your company that controls or yourself is involved in the production or distribution of marijuana, it's certainly going to apply to you. But they also will apply to issuers who have indirect involvement, and that's, for example, a fund that has an interest but not a controlling interest in a producer or distributor. Most troubling is issuers with a material ancillary involvement in cannabis-related activities. Now, I suspect that we're going to see a lot of problems with this last category. It's defined in the notice as an issuer who provides goods and or services not limited to financing, branding, recipes, leasing, consulting, or administrative services. That's incredibly broad. That could apply to tech companies that are providing software that allows producers to track their product. It could also technically apply to an accounting firm. Now, we're still in the infancy of this industry, and so there's no cases that have interpreted the notice yet, but it's clear if you're an issuer and if you're in any way involved with a company that has a US-facing marijuana business, you need to be aware and you need to be cautious. And that's why we're seeing that some Canadian companies have considered just avoiding the US market altogether. In addition to disclosure requirements for US-facing businesses, even the Canadian-focused businesses also have enhanced disclosure requirements. I'm not going to get into this, but suffice it to say that one of the more difficult requirements is providing accounting in terms of the value of your live plants and how that is changing over time. So, how has this regulatory concern affected access to capital markets? Well, essentially, companies that have US-facing operations have limited access to capital markets, and this is an important consideration when planning for growth. In Canada, there's been a different approach to the issue from the TSX versus the CSE. The TSX will not allow a company that has a US-facing business to list on its exchange, whereas the CSE will. Unfortunately, the TSX is a much bigger exchange with a market cap of $3 trillion compared to $8.5 billion for the CSE. So what does this mean? If you're an issuer, you have a trade-off. Do I want to try to get a toehold in the US market, or would I rather have easier access to capital? There's some concern amongst industry insiders that this setup will result in Canadian companies giving up the head start that they've had as a result of the more liberal regulations in Canada out of a fear that they're not going to be able to get the capital that they need to start their business. U.S. markets are another option for issuers, and Canadian issuers are allowed access to U.S. markets so long as they have no U.S.-facing business. So again, same type of choice. You can get access to this capital, but you can't take advantage of the potentially lucrative American market. We're all aware that there's several entities that have taken advantage of the capital that's in the States. These are companies that I'm sure we've all heard of, and they've all made the news in the last couple of weeks. I'm going to go to the takeaways now. Basically, there's lots of risk and uncertainty and speculation. And one way we've tried to deal with that is through heightened disclosure requirements, but that in and of itself has given rise to a different type of regulatory uncertainty. Now, we're still in the early days, and we haven't really had guidance from the case law as to how exactly all of this is going to pan out. But it is something that if you're an issuer or if you're an investor, you should be aware of. And we're going to really have to wait and see how it all gets dealt with in order to get the certainty that we all would obviously prefer. So, thank you very much.